The question is, can multi-state cooperative societies submit a resolution plan under IBC? We'll see the developments, recent developments in Supreme Court in the month of October 2025 about multi-state cooperative development societies under the MSCS Act, that is Multi-State Cooperative Societies Act 2002, and their eligibility under IBC. If you see the background, IBC and resolution applicants, briefly explaining the IBC, the enactment in 2016, the purpose is time-bound insolvency resolution for corporate debtor. Key issues here is, once the corporate debtor is admitted into CIRP is corporate insolvency resolution process, the resolution applicants, that is RES, submit their plans under section 30, and committee of creditors, that is COC, may approve a plan with which then the adjudicating authority, that is Honorable NCLAT, approves under section 31. Another angle is eligibility of resolution applicants. In ineligibility under section 29A, that is debarred promoters or willful defaulters, etc. So the question arises, so what kind of entities may submit the resolution plan? Are there restrictions beyond IBC's own eligibility list? You see the jurisprudence, for example, the question whether cooperative societies are even corporate persons under IBC. See the legal status of multi-state cooperative societies. MSCS Act 2002 governs societies whose objects extend across states. Some key provisions, example like section 64D of MSCS Act, allows multi-state society to invest its funds or deposit in subsidiary institutions or institutions engaged in the same line of business as a society. Yes, this is relevant. The Act has recently been amended by Multi-State Cooperative Societies Amendment Bill 2022, and which is passed in 2023, which inter alia creates a cooperative election authority, restricts redemption of government shareholding. So this restricts the redeem, that is redemption of shareholding, government shareholding, and establishes a cooperative rehabilitation, reconstruction and development fund. This is what we saw, the recent development in 2023. And the legal character, if you see the multi-state cooperative society, it is a society registered under the Act with members. It is not a company under the Companies Act 2013, but may have business activities. Prior judgments have held that the IBC may not apply to the societies registered under the Societies Registration Act 1860 or state cooperative acts. There is some ambiguity around cooperative societies being corporate persons under IBC. We'll see what is before the Supreme Court judgment. So we'll see the case, present case. According to a recent developments, the Supreme Court has directed the Central Register of Multi-State Cooperative Societies be made a party to the appeal filed by the Multi-State Cooperative Society challenging a judgment of National Company Law Appellate Tribunal, that is NCLAT. So the case is, the appellant is reportedly the Nirmal Ujjwal Credit Cooperative Society Limited. This is a Nagpur based, registered under MSCS Act. They argue they were eligible to submit a resolution plan for corporate debtor, that is Margie Textiles Limited, and had submitted the highest bid. This is for 170 crores compared to others are 156 crores. However, the resolution professional rejected their eligibility on the ground that their bylaws restricted business to agro-based textile credit activities. Section 64D of the MSCS Act requires that the institution in which the society invests must be in the same line of business as the society. And this Morji Textiles did not fit that line. It manufactures fabrics, cotton, man-made, while the cooperative was in the credit and agro-based textiles. So the NCLAT upheld that decision. The cooperative society was ineligible because its bylaws as well as the MSCS Act did not permit investment in that corporate data business. Also, it observed the amendments to its bylaws to permit such investment had not been approved by the Central Registrar under Section 11 of MSCS Act. So now it seeks to know from the Central Registrar whether multi-state societies like the appellant are in any manner barred from submitting a resolution plan under the IBC for corporate entity. So it directed that no final order be passed by the NCLAT until the matter is next heard, that is on 28th October 2025, and the Central Registrar's response is taken. So we will wait. Here the key legal issues to address: is multi-state cooperative society eligible to submit a resolution plan under IBC? On the face of it, IBC does not explicitly bar a cooperative society registered under MSCS Act from being a resolution applicant. But in practice, eligibility may turn on two things. One is whether this entity qualifies as a corporate person or as a resolution applicant. Second one, whether there are internal or statutory restrictions, that is MSCS Act or bylaws, that prevent the society from undertaking the business activity, investment required in the resolution plan. So the statutory restrictions under MSCS Act or bylaws, we'll just go to section 64D of MSCS Act. It allows a society to invest in subsidiary institutions or institutions in the same line of the business of the society. So if the target corporate debtor is outside the same line of business, then the society may be restricted. Society's own bylaws may restrict its business to certain sectors. Example here, agro-based credit. So the amendment, the bylaws change may require approval of Central Register under Section 11 of MSCS Act. Without such approval, society may be constrained. So in this case, the NCLAT held that the society ineligible because of these constraints. Functional restrictions and the commercial reality, if you see, even if not strictly barred, the COC may assess whether the resolution applicant has a capacity, statutory policy compliance, risk of invalidity. Example, because of its bylaws constraint would make its investment invalid. So the Supreme Court taking the Central Registrar's view suggests that regulatory legal clarity is required on whether multi-state cooperative are barred in principle from submitting these plans. So Supreme Court wants to know from the Central Registrar's views. So here interaction between IBC and other laws. IBC's section, if you see 238, gives its overriding effect over other laws. So if IBC allows resolution by any entity that meets eligibility, then restrictions under other statutes may be overridden. However, the IBC schemes does not automatically render other laws irrelevant. So eligibility of the resolution applicant is a matter for the COC and the courts. So the MSCS Act is a law under union list for multi-state societies, and thus regulatory provisions, investments, etc. may still apply. So the question is whether those statutory restrictions render society ineligible as a resolution applicant. So if the Supreme Court holds that multi-state cooperative societies can participate unless specifically barred, that opens up a new class of resolution applicants, RES, which may change dynamics in IBC. If it holds they are barred, then by virtue of MSCS Act or otherwise, then cooperative societies will need to rethink their IBC strategies. Also for COC, even resolution professionals, it raises the question of the due diligence. Check the resolution applicant's regulatory bylaws capacity to invest. So the present status is, so the Supreme Court was not yet given a final decision. It has only sought the central registrar's response and directed that the appeal proceed with the registrar's impleaded. So next hearing is scheduled for 28th October 2025. Let us see and watch. Thank you.